Hello, can I have your name, please?
My name is Daniel Magoo.
Okay, just a moment. Okay, you said your last name is pronounced Magoo?
Yes, ma'am.
And generally speaking, I appoint the public defender's office to represent at least at the arraignment stage, but I was informed that you didn't want to speak with the public defender, so are you intending to represent yourself for the arraignment?
I'm here to figure out what the charges are. What am I being charged with?
Now calling case number 25S00289. This is the State of Michigan versus Daniel Ryan Magoo. Can you please state your name for the record?
I'm trying to figure out what the charge is.
Yes, that is the purpose of the hearing today. So, as
Who's
part of
the complaining victim?
as part of the proceedings, can I have you please state your name for the record?
My name is Daniel Magoo,
Okay.
and I am not a surety of the state. I'm not a ward of the state.
Okay.
Can I ask what the charges are?
Yes, I am getting there. Please give me a moment. So, what we are here for today is an arraignment. The purpose of an arraignment is to inform you what you are being charged with and to make sure that you understand the charges. I am not going to be asking if you agree with the charges. I am not even going to be asking if you understand why you are being charged with them. The purpose is to make sure that you understand what the charges mean and that you understand what the potential maximum penalties are. So, what I have here is a misdemeanor complaint that charges that on or about or between the dates of February 15th, 2025 and June 23rd, 2025 at 6988 McKean, Lot 72. You did maliciously use a service provided by a telecommunications service provider with the intent to terrorize, frighten, intimidate, threaten, harass, molest, annoy, or disturb the peace and quiet of Alyssa McCloskey, an individual with whom you have a child in common, by using any vulgar, indecent, obscene, or offensive language, or suggesting any lewd or lascivious act in the course of a conversation or message through the use of a telecommunications service or device. This is otherwise known as malicious use of a telecommunications service. Do you understand what the charge means?
I do not understand that. I do not understand malicious use of a telephone service.
Do you comprehend that what I am saying is that you allegedly maliciously used a telecommunications service device that would generally be a cell phone. I suppose it could also be a computer or something else.
No, that didn't happen.
Okay. And
February, what were the dates? What dates?
Between February 15th and June 23rd.
Of this year?
This year. Yes. Okay. Now, as I stated at the beginning, I'm not asking you if you agree with the charges. I'm not asking you if you understand why you are being charged with them. What I want to know, basically, is do you know what the words coming out of my mouth mean?
No.
Okay. So the way that this is going to work is this. If I am not able to arraign you on the charges because I can't tell if you understand what I am saying, then the next thing that happens is that you get referred for a competency evaluation. At this point, I do not know how long that will take, and that means that you will stay where you are until we are able to either arraign you or you are determined to be incompetent.
So I don't have, I'm not, like I said before, I'm not a surety. I'm not a ward. I'm actually a protected individual, and I did no crime. There has been no body of a crime, no corpus delicti. I have committed no crime at all.
Mr. Magoo, if I cannot determine whether or not you can understand what you're being charged with, then I cannot arraign you.
Okay.
So,
if there is not a body of a crime, if I have not harmed anybody, then you can't arraign me. It's corpus delicti. It can't happen. And if you do try to enter in a plea of competency, or I don't know what is that? What you're gonna hold me here hostage until what? A body of a crime happens? When is the crime gonna happen?
Okay, so Mr. Magoo, we will not be proceeding today with the arraignment. You are free to go to the door and tell the jail that you are finished. Thank you.
Okay, here we go. Court does call the case of the People versus Daniel Magoo.
Good morning, Your Honor. Ashley Lottie for the people.
Sir, state your name.
I'm here on a special appearance, Your Honor. Magoo is Easy Elastical Trust, registered in Jackson County, on case number 2522246.
Okay, is your name Daniel Magoo?
Your Honor, that is the name you seek, and it is copyrighted and trademarked.
Okay, very well. Mr. Magoo, are you represented by an attorney, or do you wish to be represented by an attorney on these matters?
I am not.
Do you wish to be?
No, not at this time.
Let me then do this. You have two cases before this court, one being the case ending, well, let me get the full case number 25 F4 0523. In that case, sir, the complaint does allege that on March 27, 2004, you committed the offense of operating while intoxicated. Do you understand what you're charged with?
I do not.
You do not understand
There is
that?
no eyewitnesses or corroborating witnesses at all.
I'm not asking whether or not the proofs are there. Do you understand what you are charged with?
I do not.
Do you understand the notion of drunk driving?
I do not understand how I could be
We've been
charged with
through this
something without a
before on
witness.
your other cases when you represent yourself, so we'll just do it.
Are you talking about the case that's in federal court right now,
You
Your
are
Honor?
before a complaint in that case for a charge of operating while intoxicated, third offense. Because it's a third offense, that is a felony. It is punishable by up to $500 to $5,000, up 1 to 5 years incarceration. The court can order probation, 30 days to 1 year in jail, or at least 48 hours must be conserved consecutively. The court can also order community service, rehabilitative programs. The court can also order your vehicle immobilized, can order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services.
As I am here and as a trust, Your Honor, I am here in exclusive equity.
You count 2 on that complaint is the charge of operating while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs, and your vehicle could be subject to immobilization.
My license is
Count
canceled,
3.
not suspended or revoked. It
Count
is canceled
3
through the state
on
of
that
Michigan.
complaint
Canceled.
is the charge of escape from lawful custody. That is a misdemeanor punishable by up to 1 year, a $1,000 fine.
I was never arrested or read any Miranda rights accordingly.
Given that the defendant is talking in English, that he understands English, understands the nature of those charges and what he's charged against.
So malicious prosecution by
wishes
Washington
to
County
represent
prosecutor as
himself.
usual.
Sir, there is great peril in representing yourself. You will be held to the same standards as anybody apply or for.
This is a matter under the Eastern District of Michigan Federal Court. Case number 2511226.
We're not represented by counsel. I would further indicate, sir, that at any point you're in these proceedings, if you wish to be represented by counsel, you can make that request to the court and counsel would be appointed to represent you. Because of the defendant's conduct in the past in not acknowledging the court and what the court is saying, the court does make the presumption that he does speak English. He understands that. I would further state on the record that Mr. Magoo has been through this process before. He does understand that if he does wish to be represented by counsel, the court would give him counsel or would have counsel appointed to represent him in this matter. In the case 25 F309 0979. In that case, sir, you are before a complaint that alleges that on or about July 3rd of 2025, count 1 is fleeing and eluding 4th degree.
Added on by the
Police
prosecutor's
officer.
office after the
Sir,
fact.
that is a felony, punishable by up
Malicious
to 2 years
prosecution.
incarceration and a $2,000 fine plus court costs, mandatory suspension by the Secretary of State.
My Secretary of
2
State, anything
is
is canceled. I have
operating
no contracts with the state of
vehicle.
Michigan.
That is a misdemeanor.
This is
Charged
a matter of trust, Your Honor. This is a matter of trust. I am protected under a
90
trust.
days in jail, a $100 fine plus court cost. Count 3 on that complaint alleges operating a motor vehicle without security. That is a misdemeanor, not punishable by not more than 1 year incarceration and not less than $200 nor $500 fine plus court cost. Count 4 is operating while licensed, suspended, denied, and or revoked. That is a misdemeanor.
All of my registrations are through the federal government. I have federal government registration. I do not have contracts with the
Vehicle could
state.
be subject to mobilization. Count 5 on that complaint alleges refusal to obey a refusal to
I have an international driver's
police
permit.
officer. That is a misdemeanor punishable by up to 90 days, $100 fine plus court cost. I would indicate to the defendant the same admonishments regarding the perils in representing oneself that I stated in the other case also apply to this case.
Were you served your
And that
notice
if
and
the
summons yet, Your Honor?
wishes to have counsel appointed, the court would consider or would appoint counsel to represent him in this matter. And he apparently wishes to proceed.
Were you served your notice
Having
and summons
notice
for federal
of
court?
the charges, sir, do you wish to still proceed without an attorney?
I just want to know, where do you get
Do
your
you
powers?
wish
Are
to
you an Article
proceed?
3 judge or an Article 6 judge? Where
Do
are your
you
vested
wish to
powers? Can you
proceed
answer
without
that?
an attorney?
You can't even answer
look
me
it
what your
up.
powers are.
You can look it up.
No, you guys disconnected my access to any kind of law library or anything. You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my
We'll
rights.
see how much authority I have. I will assume that you wish
This is a matter
to
of
proceed without
trust.
counsel. I will assume you wish to proceed without counsel and that you will wish to continue to proceed.
Practicing
without
law
counsel
from the
until you
bench.
inform the court otherwise. Ms. Lundy.
Thank you, Your Honor. Is the court completed the arraignment for the record at this time? on both
Well,
cases?
he had been arraigned. I was just admonishing him of the perils of representing himself and that it requires in part that I let him know what he is charged with. And I've read them kind of in fully, more so than I would have because he refuses to acknowledge those. So I am satisfied that he now knows all of the charges that are against him.
Thank you, Your Honor. The people would like to be heard on bond when appropriate.
All right. What do we want to set this for? Do you wish to have a preliminary examination, sir?
This is a matter of a federal matter now, Your Honor, under case number 2511226, under the Eastern District of Michigan, under the Honorable Mark A. Goldsmith and Magistrate Judge David R. Grand. There is no proceeding here, Your Honor.
There is no proceeding. Oh, there's a proceeding.
Well, malicious prosecution is what the proceeding is.
Okay, very good. Do you wish to have a preliminary examination?
There's no proceeding, Your Honor. This is a matter that should be stayed and
What is
dismissed.
the people's position on whether or not we should set this for a preliminary examination or adjourn the probable cause?
Your Honor, I don't know if the defendant has received all discovery in this matter as he is representing himself, so I would request a probable cause date, potentially.
Because you've got to send it.
Yeah, and who restricted my phone
Probable
calls?
cause conference. You know what?
Who?
You're going to have to stop interrupting. I will give you an opportunity. You've been before me before. I will give you an opportunity to say whatever you want to say, but I'm not going to have you interrupt me and I'm not going to have you interrupt the people when they're talking. As long as you were saying.
Thank you, Your Honor. I have to there's video evidence in addition to the paper discovery. I've got to make arrangements with Lieutenant Arnett to work on that. So it may take just a bit longer. I would potentially look at the 7th, maybe, if the court would have entertained that. And then I will wait to be heard on bond when the time is appropriate.
I will adjourn the probable cause August 7th, 2025, 9 a.m. As to bond.
Your Honor, I've been reviewing ex-jail and I wanted to double check if the defendant had been arraigned. It's not clear to me from a couple of different things, but it does appear that he has been set with a $10,000 bond in 25 F30979. as well as 25L40523, each $10,000.
Yes.
Your Honor, I do think it's important that the court have some additional information, and I would like to ask the court to revisit the issue of bond. First and foremost, I think it's important the court know that the facts alleged in the newest case, the 25F30979, it does include the fact that the Michigan State trooper who pulled the defendant over noted in his police report that the defendant had a license on his vehicle that indicated he was a diplomat and that he refused to identify himself. He refused for quite a bit of time. Additional units had to be brought to the scene from the sheriff's department in order to, for lack of a better term, deal with the situation. And ultimately, they were able to identify him as the defendant, Daniel Magoo. The concern with that goes along with the other case, which is an OWI. It is charged as a third. I will note that it is a true fourth, to the best of my understanding. So there does appear to be an alcohol problem going on. And I also think it's important for this court to know, because I don't know that the court knows, the defendant has a third new case, telecommunications malicious use with a domestic relationship, that is currently pending as well. He's also been set $10,000, 10% in that matter. But I think—
Where is that case out of?
That case is out of 14B, Your Honor, before Judge Washington.
A co-defendants with the federal case that you guys are both in, and this is a conflict of interest as both of you guys are defendants in my federal case.
Go ahead.
I also understand, Your Honor, that there is a municipal case out of Canton Township that was set for a jury trial in April of this year, where the defendant failed to appear. And there were jurors, there was a veneer that had been brought in. And I bring all of this up to say, Your Honor, that the people are concerned about the defendant's ability to remain law-abiding, because I'll also note for the record that at the time that the new resisting, obstructing, fleeing, eluding case and the telecommunications malicious use case came up, he was in bench warrant status before Judge Slay, is my understanding, for refusing to come after the case here had been bound over, refusing to appear in person. I say all of that to say this: I do think that $10,000 is too low. And I also am going to request a scram tether, because this is an OWI fourth alleged, as well as a GPS tether, given his history of failure to appear and failure to comply with court regulations. Thank you, Your Honor.
Is the bench warrant before Judge Slay still out?
She has bond denied in her case now.
His bond's been denied in that?
Yes, that's correct, Your Honor.
Got it. Anything you'd like to say?
Anything to do with any contracts with the state of Michigan are void ab initio for a matter of law, as I have an canceled driver's license and I have an international driver's permit. And that also relates to the Canton case that they're trying to stick me for a driving unlicensed suspended citation, in which that I have an international driver's permit, making it also void. All of my matters, including the vehicle that I'm registered under, are registered to the federal government, not the state, under the Federal Motor Carrier Safety Administration. All of these charges are frivolous and a part of a long pattern of malicious prosecution by Ms. Londy, the Washtenaw County Prosecutor's Office, and quite frankly, you, Your Honor.
Hearing argument regarding bond, the court does believe that it was an abuse of discretion, given the circumstances of this defendant, to set his bond at the $10,000 figure. After hearing argument, viewing the file, the court does believe that not only does the defendant pose a risk to the public,
No victims.
I do believe that the defendant is a risk of flight given those circumstances, and has indeed, or at least is charged in this case, refused to obey or fled and eluded.
That was added on afterwards. The police officer did not report that at all.
The court, given those circumstances, would in each case raise the defendant's bond, grant the people's motion. Defendant's bond in each matter is set in the amount of $50,000 cash here. Thank you.
The tethers I requested, if he is able to post, Your Honor.
I will.
Thank you.
Thank you. If everybody doesn't mind, the court's gonna take a very brief recess, and I will come back and we will finish them.
All right.
Gosh, yes, ready. Here we go. I spend my life writing. Easter,
Yes, sir.
in anticipation about what I'm going to go through right now. This is absolutely all your fault.
Oh. In anticipation.
In anticipation of it, I'm just letting you know.
Well, let me apologize in anticipation for this being my fault. I am sorry.
Court does call the case of the people versus Daniel Magoo. State your name.
Daniel Magoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523. I have a couple things I'd like to point out about a couple of the matters here today.
Go ahead.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that charge is invalid on
That
its
were going
face.
to be addressed, that would be addressed at a preliminary examination, so as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenged the prosecutor to prove all 3.
Sir,
Yes,
you wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed, a motion for all dismissal on all these charges.
They're not going to be dismissed.
No, okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion for this.
Ms. Lumbee has let me know that all paper discovery has been sent to Mr. Magoo in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case. So they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. Magoo, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the
He
video.
has all video discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. Magoo, are you going to have an objection to the adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So, given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a speedy
So
trial.
you want your preliminary examination. Those are coming down to the jail to him.
I expect that you would have them early next week, so if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th and then
have them as well.
he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination, it's being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 5 different counts, excuse me, including and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200, nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice, which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service, any rehabilitative programs the court deems necessary. Court could order you to pay the cost of the prosecution and the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, excuse me. That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. Mr. Magoo, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I will. I have requested assistance given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be represented by?
I've called the
Well, Mr.
prosecutor.
Magoo, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I advise you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you. If that is a yes or no.
I would like legal assistance, yes, Your Honor.
I'm going to take that as your request for counsel, is how I'm going to take that. And so these two cases now become public defender cases.
Thank you, Judge Torsia Feaster, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
He's asked for examination in the case, and so I will set these for preliminary examination.
Okay.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations. And I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, amend his bond, and he's requesting the release, Your Honor, PR bond.
A response from the people regarding his bond.
The people would ask the bond be continued, and he also failed to appear before judges.
Yes.
But also with respect to the other comment, I'll wait. There are pleadings filed by the defender's office. Respond to that. And I guess my one remaining point would be, should with the court's appointment Eastern the public defender's office, I will make sure that the initial discovery that I referenced is served on the defender's office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would. In this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That bond has been denied. So
That's what I
would
Mr. Childer said.
in any event. But also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in this bond in this case,
I have,
that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And
I understand the presumption of innocence.
a lot of these are facially invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff,
I was not.
I understand.
I was not.
Custody of.
I was dropped off at the hospital and they later tacked on charges just like the fleeing and eluding charge.
Not beat that out. And that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
Thank you very much, Judge.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
Many of those, do not interrupt me.
Well,
including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. Complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that he's attempting to manipulate the system. He will be dealt with by me as I deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there, they will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So,
Been aware of such note or such filings were being received by our ethics committee yesterday. At this point, we can truly proceed with this case. And last time until I did otherwise from the elected prosecutor.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are raising no motion for change of venue, denied.
Thank you very much, Judge.
Bond will continue. Thank you.
Somebody be able to continue.
Appreciate it. Done with it. Robert. You swear to affirm the information dated, the search warrant affidavit. I didn't do that right there. I will sign these in the end and get right out. Yeah, okay, thank you, sir. And Mr. Priester?
I'm sorry too, Judge.
No, you know, I'm just gonna say sometimes there's just karma, man. All right.